Um, my name is Joanna Szymańska. I am acting head of Europe office at Article 19, Global Freedom of Expression Organization. And I have the pleasure of moderating our third panel today about country initiatives and draft regulation proposals. And we have excellent speakers with us today that who will share their experience from several countries. We have UK, we have Georgia, we have Lithuania, and Poland. So I think it will be a very interesting discussion. So I will start with introducing our panelists. Susan Coughtrie. She has been director of the Foreign Policy Center since January 2023. Susan joined FPC in 2020 as project director for the Unsafe for Scrutiny project, which explores the risks and threats facing journalists uncovering financial crime and corruption. The findings of this research led Susan to co-found the UK Anti-SLAPP Coalition in January 2021, which she continues to co-chair. Mari Kapanadze, she is a human rights lawyer currently serving as the director of the Civil and Political Rights Program at the Georgian Democracy Initiative. For more than a decade, Mari has been monitoring media freedom, freedom of expression, assembly rights, and discrimination cases within the context of Georgia. And Mari is also the coordinator of the Georgian Anti-SLAPP platform, and she is actively involved in national and international advocacy to tackle SLAPPs. Indrė Makaraitytė from Lithuania is a senior journalist and head of the investigative board of the Lithuanian National Television and Radio. She is an author of many articles and investigations related to the topics of political funding, interest groups, and political corruption, as well as Russian propaganda and disinformation network in Lithuania and Russian influence in the Baltic region. And Paulina Milewska, she is a PhD researcher at the European University Institute, where she focuses on SLAPPs in illiberal context and the EU response to this threat. She works as a senior expert at the Helsinki Foundation for Human Rights in Poland. And in September, she will start her Fulbright scholarship at New York University. Before I start asking my first question, I would like to share my personal story and why am I so thrilled that we are having this kind of discussions now, not only here in Warsaw, but also in many other places in Europe. As a daughter of a local journalist amateur in the 90s, whose main job was not journalism, but he used to write to local newspapers about some corruption cases in the north of, in a small town in the north of Poland. I know very well how it is to live in the anxiety of SLAPPs. Back then, obviously, no one called it like this, but the issue is not new, and it's good to remember that many activists and journalists, they have been targets and victims of SLAPPs, not only in the recent years, but also years before, just like my father. He was sued. It was a criminal defamation case, so the infamous Article 212 in the Polish Criminal Code for one of his articles by a local mayor. And I remember very well this feeling of loneliness that he faced. He didn't know that it was a slap. He didn't know if he could turn for help anywhere. And I also remember this feeling of anxiety because since it was a criminal case and his main job was at a public institution, he worked at a museum back then, he knew that if he was convicted, he would have lost his job. So I remember very well this pressure and this fear what will happen to our family. In the end, he won. The charges were dismissed, but unfortunately, the whole experience led him to drop activism and journalism at a local level. But I think I can say that his efforts didn't go on waste because I am continuing this fight, and I'm so happy that we are now at this moment in history when we can hopefully count on the future situation where slaps won't be a problem anymore for us across Europe. So I would like to start with asking Susan about the experience from the UK, and if you could give us a bit of a background. This will be a question to all of you, but starting with the UK, a bit of a background about around the kind of slap cases that are the most common in the UK. And what kind of cases are most common, and what is the scale of the problem in the UK?
Thank you, Joanna. And first of all, just thank you for sharing that story. I hadn't heard that before. And it was really good to hear it. And I'm a little bit reminded as well, listening to the speakers who spoke earlier today, that I feel relatively new to the sort of slaps sphere. I only heard of slaps 5 years ago from the work that, people that you've already heard of, like Matthew and Flutura and Charlie, were already doing in Europe. And slaps have never touched me personally. My entry point, as you mentioned, I lead a project called Unsafer Scrutiny that looks at risks and threats to journalists who uncover financial crime and corruption. And when I used to work at Article 19 with Joanna, that's what I saw from the work that we were doing in the region, in Russia, in Azerbaijan and other countries, that it was the journalists who are uncovering financial crime and corruption that were paying the highest penalties. Not the people who were committing the crimes in the first place. And very sadly for me, as a British citizen, I realised that much of that dirty money was ending up in the UK and in London, quite specifically. So I set up a project to look at that, to research it more. And one of the first things that we did in 2020 was we did a global survey of 63 journalists working in 41 countries, asking them, who are working specifically on this topic, what were the kind of greatest risks and challenges that they were facing. I'm sad to say over 70% were facing some kind of risk and threat, and it ran the whole gamut. But of those experiencing threats, over 70% of them were experiencing legal threats. And most depressingly of all, the international leading source of those threats was the UK. And that was as high as those sort of threats identified by the respondents coming from the EU and the US combined. So that was a real red flag for us. And we really pivoted at that point and decided to focus on the UK. It's why we set up, together with a colleague from Index on Censorship, set up the UK Anti-SLAPP Coalition in January 2021. And I think we're going to talk a little bit more in the second half about the work that we've been doing. But just to come back to the research and why we decided it was so important, it's because largely we didn't really understand why. Why was the UK this hub for cases? And I'm not a lawyer. I always like to say that, especially when there's lots of lawyers in the room. But I kind of was of the opinion, well, we've got a good rule of law in the UK. If you've got a problem, you go to court. Judge decides, you sort it out. All's fair and square. But actually diving into it much more over the following couple of years and ultimately to the production of a report we called London Calling in 2022, which we published together with Article 19. We looked at 35 cases in the UK, and the idea wasn't really to do deep dives into each of the cases, although we have subsequently created quite a lot of case studies, and I think there'll be, if you are at all familiar with the UK context, ones you may have heard of, like the cases against Catherine Belton, the journalist who wrote Putin's People, when she was sued by 4 Russian oligarchs and the Russian state oil company Rosneft in 2022. Tom Burgess, who was also sued for a book he wrote about Eurasian Energy Company. Elliot Higgins, who's the founder of Bellingcat, an open source news agency, who was unbelievably but sued for tweets by Yevgeny Prigozhin to news articles that may suggest that he was a warlord and possibly the head of Wagner, which of course we all know, now is definitely the case. And so how do these cases get to the stages that they are, and why actually do so many not? And what is the UK system like? Well, basically the UK is an incredibly expensive legal system. If it's a defamation, and we know it's not just defamation, but if it is defamation, it costs between 50 to 100,000 for an early hearing, and it costs a minimum of £500,000 to defend a case to trial. £500,000, and that's the floor. So we're talking huge amounts of money, which I'm sure many people in this room will understand is not readily available to those often speaking out in the public interest. They also take a very long time. So most cases that have gone all the way to trial take about 3 years to get there. And so even if you want to get that far, you've got to have pretty good resources. And then in terms of the defamation, the burden of proof is on the defendant. And so it's up to you to prove what the truth is. And the truth is actually decided by a judge in an early stage. So you may have thought you're putting forward something, and a judge will decide what that single meaning is, and that's the truth that you then have to prove. So that can catch you out at an early stage if you ultimately, the truth you're proving is not something you actually necessarily meant. So there are, various challenges within the legal system, and I think many people who are facing a threat even at an early stage, realize what potentially stands in front of them, and they don't have the resources to necessarily fight it, even if they believe it's true. And so we do see that, as we know with a lot of these cases, they start with a letter, they start with an early kind of action, and they can last weeks and months before they even get to trial. So if they are successful, then it means that obviously that article or whatever goes down, it's taken down, and then there's a huge vacuum of information. While not all SLAPPs relate to economic crime, my interest obviously was related to economic crime, and a lot of the cases that I researched were connected to that. It also, in another way of bringing a case to the UK, you have to establish a reputation. And because so much money, dirty money, does end up in the UK, it means people are buying visas. Well, it's not so easy to do that anymore, but property, sending their kids to school. They're basically establishing a reputation in the UK, which means that the previous provisions that tried to prevent libel tourism didn't really work. So I'll stop there, but certainly I think it's now pretty clear from both, what work that we've done as a coalition, but also the government's own recognition and own consultation, that SLAPPs are having a pretty chilling effect in the UK. So yeah.
Thank you, Susan. Mari, so I would now turn to you with the same question.
Good afternoon to everyone. It is a pleasure to participate in this incredible conference and be able to share the Georgian experience regarding the addressing SLAPPs in the Georgian context. The dialogue and the discussion surrounding the SLAPPs phenomenon is only just beginning to take shape in Georgia. It was just in 2021 when Georgian Democracy Initiative, the organization that I'm working in, found itself approached by media organizations, activists, and other public watchdogs seeking legal aid to provide for them in defamation cases. And this was the first time when we saw the very strange similar patterns in those defamation cases. In particular, that all of them were taken and brought by highly ranking politicians and members of the ruling party, as well as their individuals affiliated to them. And secondly, that all of them were targeted against the critical media outlets, especially the critical broadcasters that are the most vocal in terms of exposing the corruption and other malpractices in Georgia. In particular, we have, and since that we have observed that around 15 cases were reported in 2021, and at this moment we have identified at least 41 defamation cases that share the same pattern that I have mentioned. To list some of the main features that we have in Georgia regarding the SLAPP cases. The first one is that I have already actually mentioned. It's about the authors of the SLAPP cases. And like Serbia, we share the similar situation that SLAPP are used especially by the government and ruling regime to suppress critical voices in the country. We have plaintiffs like state security, head of the state security service, minister of defense, other ministers, mother of recent prime minister, members of the parliament, and so on. For example, one of the very obvious case was cases taken by the mayors of different cities of Georgia. 11 different mayors applied to the court and brought the case against one particular TV company, and this case was actually also mentioned in the report of the Council of Europe, based on which the resolution was adopted by the Parliamentary Assembly. And second feature is the targets, who is the target of SLAPP cases. And here, as I've mentioned, we see that most of the defamation cases that we qualify as SLAPPs are targeted against critical media outlets. But apart from these two main features, I would like to here mention and stress that SLAPPs should be discussed in a broader picture in the Georgian context. And what we have observed is that SLAPP, unfortunately, is only just a part of the bigger campaign against civil society in Georgia. I think my Serbian colleague has already mentioned the same pattern and approach in Serbian environment. And it's the same in Georgian context as well. Media freedom has been deteriorated throughout the last years in Georgia, and we see that it is not only SLAPP cases and taken against journalists, but physical and verbal attacks on specific journalists, specific journalists, as well as fines imposed by the regulatory authority, the Communication Commission, against the broadcasting companies. Therefore, the media companies and media outlets are in a very troubled situation. They struggle from financial resources, and that's where this is the place where the civil society organizations like GDI started to actively engage and provide the legal aid for them, because many of them even suffer from lacking sufficient resources for providing legal aid for themselves. Therefore, I think that it's very important to note that unlike many European countries that are regarded more democratic, in non-democratic regimes, SLAPP has pretty much different content and place, and is one of the weapon and tool for the regimes to vanish civil society in the country. And here I feel obliged and responsible to stress the ongoing situation in Georgia. I am sure many of you are following what is happening right now, that the Georgian government tries to adopt the so-called foreign agent law. they had the same attempts last year. At that time, we managed to force them to withdraw that law, but it seems that they are still having the same wish. I would like to here to mention that of course, the SLAPP is one of the important problems that we are continuing to tackle and address, but unfortunately, Georgian civil society as such faces much bigger problem. It is a problem of being existing as such, and we see that even if this law will succeed and will be adopted, this will be a start of ending of Georgian civil society, which has already happened in Russia, for example. Therefore, we think that it's very important for us, both for Georgian civil society as well as international institutions, to use any lawful, of course, tools and stop this process. Otherwise, I think that it will have not only consequences for the Georgian civil society and people living there, but also we should see this as a negative consequences for the European region as such, because like Ukraine, I think that Georgian situation will have a decisive factor in the region, and if Georgia will not survive in current struggle, this will have a negative effect to other countries, other neighboring countries as well. So sorry for my for going a little bit far from SLAPPs, but I needed to mention this. As for the other features of the SLAPP cases in Georgia, here I would like to mention that in Georgian context, we see also that very often the authors of the SLAPP cases try to create artificial obstacles for the journalists, and even if even journalists are trying to reach them and ask for the comments, for example, they are avoiding and are not giving any comments to the journalists. And then they are using this as one of the evidence in the courts, saying that media coverage produced by the media company was only from one side, and they didn't check any information with other with relevant stakeholders, whereas journalists usually try to approach to the respective state institutions and the heads of those state institutions to report on the issues of public importance, but sadly very often they face a problem of accessing the public information, and are denied to have any comments from the respective representatives of state institutions. And very often these the so-called slappers are also not using other available mechanisms like press councils or other non-judicial or judicial mechanisms, but rather are taking those cases directly to the courts, which we think is one of the indicators of having a SLAPP case, and that the intention is that they don't want just to protect their privacy and reputation, but rather than suppress criticism in the country. And very briefly about the courts and the judges. In my question, I have already mentioned that sadly there is another big concern regarding the judiciary system in Georgia. It is highly regarded problem not only by the national human rights organizations as well as by the international institutions, our international friends, that Georgian judiciary is not independent and impartial, and the SLAPP cases are one of those cases where we see this problem, because unfortunately the cases that we are litigating in the national courts, they don't have much success, even though the law itself on defamation in Georgia is pretty much good. We don't have a criminal defamation. We have abolished it just in 2004. But still, even though the burden of proof, for example, in Georgian case, it's on the plaintiff, not on the defendant, the judges are misinterpreting and misapplying this law and shifting the burden of proof unlawfully to the defendant. Therefore, we have a consequence that all those cases are ruled in favor of the plaintiffs, and therefore I have heard this morning that very often SLAPPs are not for winning the case, but rather just to engage, force the public watchdogs to engage in these proceedings. In Georgia, it's not the same situation. For them, it's also important to win those cases and show off that and expose to the society that you see, I won. Therefore, they were wrong about me. And very lastly, it's about that all of those cases that we have litigated and we have observed as a part of this big campaign, all of them are matter of public importance. They are not about any private life of those state officials or any other matters. They are about the allocation of budget or some possible corruption and many other issues that the society needs to know. I will stop here and will be happy to answer further questions. Thank you.
Thank you. Yeah, it works. Thank you, Mari. And I think it's very good that you mentioned also the draft foreign agent law, because it shows that you have growing challenges and you are operating in a increasingly hostile environment, which of course one way or another affects your work. So we stand in solidarity with Georgian civil society, and hopefully this time again the government will drop this draft legislation. So thanks again. And now it would be great to hear about the Lithuanian perspective, which is I think a bit different, because we are mostly talking here about draft initiatives and some plans, and Lithuania has already a bit different specifics. So over to you.
Hello, I'm so happy that finally I'm representing a country there are less problems than all around. It's like, you know, I'm so proud of the community of journalists and our civil society, because we had issues, but we somehow managed, you know, to overcome. And today I can tell you that we had amendments to our civil code and civil process code in 2021, and then the discussions in European Parliament just started, and now our lawyers can say, and experts can say that, okay, we were very fast, we wanted to be very fast, and now we will have to amend again because the text in our civil code is already old, and the procedures are too difficult to fight with SLAPP. So, but we had a very nice discussion during the lunch break with the colleagues here, that, you know, what it's written in the laws and what is written, not always not always the same. The life is the same. So. The problem in Lithuania, and we faced it as investigative journalists, actually they can use lots of different institutions, people we write about, we report on. They can use other procedures, we can use other institutions for stopping actually journalists to reporting on them. And we had one case in 2018. We did an investigation about one big businessman. Actually, we didn't know that he is that influential, and you probably would understand why. He used to be a representative of Belarus Kali It's a Belarusian fertilizer giant in Lithuania and a port city. And we found out that he financed the election campaign of the then general director of the port to the mayors of the port city. And not only him financed the campaign, but all port businessmen personally, because it is prohibited for the companies to finance elections. But the leaders of and the heads of family members of the businesses in the port, they financed the campaign of the then Director General of the port, and it happened that person, that Vaitkus, the Director General, he ran under the flag of the then ruling political party. So it means that Igor Udovitsky, he financed the ruling party of Lithuania, and it was quite a good investigation. It was we disclosed very interesting facts, and of course that man reacted because he had never been so public before. Nobody knew him, and of course he is rich and he is influential because you probably understand that if he is a partner of the then ruling political party, so it means that he's not that, lone wolf. And he didn't go to the court, but his business partners, all business associations which united port companies, local politicians, even that port company, they sent more than 55 complaints to different institutions, that Ethical Commission of the Journalists, that self-regulatory institution, also to the inspector of the journalist ethic. And it means that, as a public broadcaster, we had to report on these complaints, and we had to reply to these complaints and to go to the hearings of these complaints. And it took us, I think, 2 years to get rid of that case, but it means that we really had to work on that. And what we found out, as accidentally, of course, because we spinned into that process, that the members of that self-regulatory commission of the journalists were appointed by the ruling party. Actually, we didn't know that, and because we didn't care, because that nobody cares about those, strange institutions, which you don't even know that they exist, up until you do not appear in front of them. And I remember the question of one of the members of that commission, and he asked, "So why do you suddenly decided to get interested into the problems of the agriculture?" Meaning that if you write about the fertilizers and the company of fertilizers which finances ruling party and the campaign, it means that it's a question of problems of agriculture. So it's and why I'm talking about this example, because when we parallelly, it was another case. some local businesses in the same city, they sued one local journalist, and we had, and our team and that journalist, we had the same problem, because the interpretation of the public figure in Lithuanian courts was very narrow. We had a very wide interpretation of the public figure, like a definition explained by the Constitutional Court, but the practice of Lithuanian court was like, was very narrow. And that Igor Udovitsky and small businessmen in that port city, they claimed that they are not public figures. That's why we couldn't, write about them and couldn't name them and couldn't, use their names and surnames. And right before our case ended, in the case of that local journalist, the court decided that, yes, that businessman is a private person, so the journalist couldn't write anything about him. But then our community of journalists, we really made a big wave and kind of created a scandal, and we raised that question publicly. And the outcome was that the chairman of the court decided personally to bring the case back to the beginning, and that journalist won. And now we have, a broad, normal interpretation and definition of the public figure, so that opened the doors to the journalists to write about every businessman, every head of the company, every shareholder which has more than 20% of the shares of the company. So they are like public figures. So, but this happened because of the community and civil society and the society itself. So what we had, that we have amendments to the civil court in 2021. It's also because of the journalists. But now I'm listening to all the cases and what is the situation in Georgia, in Hungary, even in Poland, in other countries around, and I understand that you cannot take it for granted. You always have to be very you put lots of attention to what's happening around, because it's always they are trying. They're always trying to do to involve, to make influence, and what we really know that only those people who are representatives of the Russian money, Russian business, Belarusian business, only like in cases in Lithuania, only those people they dare go against journalists or NGOs. So this says a lot about about the culture and about the environment around us. So maybe.
Paulina.
Thank you very much for all of the super interesting stories from different countries, first of all. Second of all, Joanna already gave some background to what is happening in Poland and how SLAPP cases can look like here. But let me show this from different perspectives, and I'm lucky enough to have 3 different perspectives. First of all, I used to work for Gazeta Wyborcza, in which building we are now. So it's kind of journalistic perspective, then my academic perspective, and Helsinki Foundation from human rights perspective on SLAPPs. So starting with Gazeta, what happened with Gazeta Wyborcza in terms of SLAPP, I will tell the story from the time when I used to work there, and that was 2018, 2017. We were talking about the number of cases we have against Gazeta Wyborcza, which were initiated by people like the back then Minister of Justice, Zbigniew Ziobro, Telewizja Polska, Jarosław Kaczyński himself. So all of these extremely powerful figures from the government at the moment. And that was something we were talking inside the newspaper because nobody had an idea of going out with these cases and discussing them publicly. And I was just like talking with some friend of mine who used to study human rights abroad, and he told me, actually, you have a lot of SLAPP cases against you. And I was like, whoa, that's interesting. What is that? And then he helped us with getting in touch with Article 19, actually, which led to contacting European Center for Press and Media Freedom and Futura, who supported Gazeta Wyborcza very generously because we were really spending a lot of money on defending that cases, and we went public. So we started talking about the number of cases, who is initiating them, what is happening, like what does it mean for the newspaper, the whole perspective that was quite complicated at the moment, and nobody was talking about SLAPPs really. And that led, if I can say that, to the fact that many other newspapers, many other news portals in Poland started saying, oh, well, we also have some cases from Ziobro, we also have some cases from this and this organization which is connected to the government. So the discussion was started, the word SLAPPs was out there, and I think it started a bit this process of feeling, okay, you have a defamation case, but it's not something that should be shameful as you are a journalist. It's not something that is like bringing this shadow over your professionalism. It's something that can be really an abuse against you. And there are organizations, there are people that can support you and that can like help you with that because it's a long process and you don't have to go through it alone. So that was, I would say, one-to-one connected with the political situation that was there at the moment, and maybe just to mention now the academic perspective. So what we had back then in Poland was a illiberal government that, first of all, was introducing this authoritarianism or trying to introduce it through different abuses. So what we are doing in 21st century is not taking tanks to the capital city and saying, hey, we will have authoritarianism from nowadays because they are entangled in different international obligations, they want to be in the EU, etc. So they have to slowly abuse the system in order to twist all of the organizations. And SLAPPs are one of the ways in which you can do so, because you won't like ban the free press. You will de-invest, you will take over public television, but with private media, you can like try to threaten them. And like it happened with Gazeta Wyborcza. At the end, they had over 100 SLAPP cases. It's a lot, even for the biggest newspaper in the region. Another thing is SLAPPs are, according to Professor De Burka and Young, one of the indicators when we want to define if the country is falling into the authoritarianism path. So they will do the misappropriation of human rights, so use things like freedom of speech, but with the new definition, and also slap those who are really exercising the freedom of speech. Right now you can like say, well, but government change in October, so there shouldn't be a problem in Poland. And sadly, it's not the case, because of course we are hoping and that it won't happen that now the prime minister or the head of the leading party will slap people, but looking from the perspective of Helsinki Foundation, we know that for years and years, slaps were occurring in Poland, that they were present, even though there was no name for it, and there will continue on the level of at least local journalists, and that won't change. And it's not only the journalists who are threatened, but also activists, for example, environmental activists. We might see in the future more and more cases like that, because we have a lot of young people who are motivated to act to counter climate crisis, and on the whole horizon of the political spectrum, the answer to that might be SLAPPs. In the last years, we really acted in different, like dozens of SLAPP cases, doing amicus curias or different ways of support. And I wouldn't go as far as saying for sure that after October everything will be different and we don't have to act on SLAPPs and we don't have to like be super careful about how to protect potential victims and those who already were victims. Thank you.
Thank you, especially that I think that not all of the cases initiated by the previous government officials or state-owned companies have been withdrawn. Yes, that's something we would expect to happen immediately after the change of the government, but to my knowledge, some of the cases are still ongoing.
Yeah, that's true, and still some journalists and media outlets are waiting. And even in the case of Professor Sadurski, who is very well-known Polish constitutional law professor at the University of Sydney, against whom Telewizja Polska started two cases, one criminal, one civil, due to one of his tweets. He had to wait, I think, till last month to the second case being withdrawn. So it's a slow process, you're right.
So I will now move to our second question, which will be about the initiatives in your countries to counter SLAPPs, draft proposals that you might have. Of course, in the case of Lithuania, there is already a legislation in place, so we will shape this conversation a bit differently. But let's start now with the UK, because I must say that for many of us, the UK anti-SLAPP group has been an inspiration, how we should be moving things also in other countries, including in Poland. You've done really a lot there, so it would be great to hear more about it and what stage now the process is.
Thanks, Joanna, and for those kind words. I thought I'd start by trying to do a quick summary of progress we've made so far, and then talk a little bit how we got there, and then very much focus on what we haven't got and what kind of further we need to do. In terms of legislation, we now in the UK, the UK have adopted in their national legislature for the first time anti-SLAPP provisions, and they were adopted within a bill passed last October called the Economic Crime and Corporate Transparency Act. So they pertain only to SLAPP cases that relate to economic crime, but they have already passed. They only pertain to England and Wales, though. We also now currently have going through Parliament a standalone bill on SLAPPs, which would cover any cases, so not just having that economic crime component. As a coalition, we've always looked at different, not just the laws, but different areas. So I just wanted to mention also regulation, because we've done quite a lot of work in that area, particularly with the Solicitors Regulatory Authority, which has oversight of solicitors that work again in England and Wales. As you probably guessed, we're quite jurisdictional with inside of the UK. In November 2020, the SRA published a warning notice on SLAPPs, which was one of our key recommendations, which for the first time recognised that SLAPPs was a problem and gave particular guidance. So it's sort of a warning notice is sort of partly an educational tool, like this is an issue we're concerned about, and this is why we're concerned about it, but also adds a bit more to their regulatory framework when assessing complaints. And at the time that they adopted that, they also announced that they were investigating 20 complaints linked with SLAPP concerns. That's currently risen to 60 cases that we're aware of. And they've also conducted 2 thematic reviews into the issue of SLAPP. So in terms of the focus on this topic, we've certainly seen a lot there, plus other regulators now, including the Legal Services Board, which is kind of like the regulator of regulators, a super regulator, that also regulates barristers as well. In terms of other non-legislative, a big win for us last year was the UK's National Committee on the Safety of Journalists recognising SLAPPs for the first time in the UK's National Action Plan. That was something the coalition had been working on since the very beginning, actually. This is a relatively new initiative, well, for many countries, but in the UK, the committee started in 2020, and the action plan was published in 2021. So when they did a refresher of the action plan last September, they included SLAPPs. And we think that's incredibly important because, this has been mentioned already several times, SLAPPs don't just come in isolation. So the action plan already covered physical attack and online harassment, and our argument was, I don't think actually in the coalition in the UK we've ever seen a case that's just been about legal stuff. There's always usually something that comes alongside it. So it's important to have that recognition. And then another sort of policy change that we saw, I mentioned earlier the case of Elliot Higgins, who had legal action brought against him by Yevgeny Prigozhin, who at that time was already sanctioned in the UK. And there was a lot of concern and outcry, rightly so. How had a sanctioned individual been able to get around those sanctions in order to hire lawyers in London to pursue Elliot Higgins? And the case actually collapsed after the full-scale invasion into Ukraine, and Prigozhin's lawyers decided to withdraw. And so Elliot was basically left with £70,000 out of pocket. As I mentioned, even at an early stage, costs can get very high. But as a result of that case, last year the government announced that there would be no more automatic granting of licenses to sanctioned individuals to pursue legal cases, which is quite important, particularly when we think about the number of sanctioned individuals now, like Roman Abramovich and others who had sued journalists in the UK. I mentioned Catherine Belton earlier, so that was quite important. In terms of all of that progress, how did we get there? Well, as has already been mentioned, we set up the coalition in January 2021. We came together as, I think now it's about 25, 30 organisations, but a lot of also individual researchers, a lot of legal experts, and other, academics, other interested parties. And the first thing we did was set out a policy paper in the summer of 2021. We said, look, here's the problem. We haven't got all the solutions, but this is what we want to address. And huge thanks to Charlie Holt, my co-chair, because he did a lot of work with lawyers in the UK, trying to work out, okay, what already exists in the law? Are there tools that we could already use to throw these cases out? The sort of answer was yes and no. There were some things there, but fundamentally judges weren't actually using them. And the outcome was, actually, we really do need a standalone anti-SLAPP law that will say what it does in the tin and, get rid of these cases at an early stage. And then Charlie spearheaded what we have now as the model law, which we published in November 2022. And this is where I come to some of the bad news around our laws, which is that they don't live up to the standards. So even the law that has already been adopted last year had some fatal flaws, and those have been carried over now into the bill that we have going through Parliament. So as I can go, and maybe we can go into technical stuff if people are really interested with questions, but the point is that I think it was raised also in the previous session that you can sound like you're doing the right thing, but unless you're really getting very clear on the detail and the language, it's possible for it to be not that helpful at all. Just a quick note on the other things. With the regulation and the investigations, we have yet to have any kind of real findings from that, and the process has been going on now for a couple of years. I know these things take time, but that's frustrating too. And so we'd like to see more action, particularly about ethics, and I know that's a tricky topic in terms of professional behaviour. And some of the lawyers in the UK have been upset that they've been conflated with their clients. And we very much say, actually, no, it's about how you are representing your clients and the tactics you use. As I mentioned, in the UK, we see a lot of aggressive legal letters at an early stage, making it very difficult for people to respond, and some of the tactics they employ that previously were not getting any kind of purview and were happening in the darkness. And I think, as I was also saying, I think it was Matthew was saying about people feel much more comfortable to talk about SLAPPs now, and I think that that's an important thing. And that was really the third strand when we set out as a coalition. It was legislation, it was regulation, but it was also cultural change. And that's so important. People are talking about SLAPPs now. There's a lot more understanding. I mean, it's a term that just people weren't talking about in the UK 4 years ago. And we've done, aside from reports, including the one, our joint report, London Calling, we've held 3 conferences now in the UK. We've given platforms in various different events. And also I must shout out both parliamentarians. There's been an active cross-party group of parliamentarians who've been pushing on this issue. And also many wonderful defence lawyers. I'm like Matthew earlier, got to shout out the great lawyers that do a lot of good work to help as well support these cases. So yeah, I think that's it. Happy to answer any questions.
Thank you. Mari, over to you.
Yes, before going to answer your questions regarding the initiatives, I just wanted to quickly also give some examples to have more ideas what kind of SLAPP cases we have in Georgia, and then I will move to the initiatives. Like we have, for example, one case where the business partner of the family of the former prime minister has sued one of the TV companies who made media coverage about the corruption scheme of the former prime minister in his home region. And in that media coverage, the journalist has mentioned that business person was known in his neighborhood as a lion. And he disputed this statement, and actually in the court argues that he's not an alien. So. And yes, he's arguing that he's not alien. And there is a second example where the claimant is arguing that he's not an aggressive person. So that's another example. As now of moving to the initiatives from the Georgian perspective, I can list and categorize them in 3 main directions. The first is the strategic litigation, second is the advocacy, and third is awareness raising. To start with the strategic litigation, I have already mentioned that we are providing very actively the legal aid for the media companies and journalists, and we do it not only on the national level, but we are looking ahead to submit those cases, the strongest cases before the European Court of Human Rights, and therefore we look those cases on that level as well. And of course, providing a legal aid is very crucial for many media outlets. As I've mentioned, they struggle from financial difficulties. But it is important to note here that we use this venue, like legal proceedings, not only providing a legal aid, but also for the awareness raising, in fact, because even though there is no any SLAPP regulation in Georgia, we started to discuss this issue and raise this issue during the court hearings, and it is the fact that the judges as well as some of the respondents or their lawyers are not respondents, but actually the claimants are hearing what is the SLAPP from us. So we are using a judicial avenue for kind of lecturing them about the SLAPP. And I remember when I was personally also engaged in some of the cases where the judges had like big eyes looking at us, what they are speaking about, looking around, what is SLAPP, what is happening, and yeah, they were like, what's SLAPP and so on. Now they at least used to get this term, at least. And we already have some cases when actually the opposing party was obliged to respond to our arguments when we are saying that what you are doing, it's the SLAPP, and they at least had to respond and start to argue that no, that's not SLAPP. Although, like we tried, even without any legal regulations in a Georgian legal framework, we tried to oblige the opposing party to defend, respond to this, and also raise awareness among the judges through this judicial proceedings. The second issue, the second strategy that I would like to share, it's about the advocacy efforts, and here I don't mean to adopt the regulations, and I will speak a little bit late why it's not a priority right now in Georgia. Within the advocacy, I mean more international advocacy and national advocacy to make Georgian case visible and what is SLAPP and how it is interpreted or applied in the Georgian context. As a part of this, since 2021, when we got this information, also from first time, what is the SLAPP, we started to be actively engaged in all the international and foremost the European initiatives against the SLAPPs. We joined the Case Coalition and also attended some meetings, including the Anti-SLAPP Conference in Strasbourg 2 years ago, and used this avenue to raise the awareness about the Georgian situation, because until that there was no any data or information what was happening in Georgia. And as a result, we managed to make this happen, that Georgia is now in many of reports, including the case report, as well as a report produced by the Council of Europe. And therefore, this is already like an intermediary step for us, that now the international society already knows about the Georgian context and situation. And actually, it is our plan here that to make Georgia as a hub of the regional initiatives against the SLAPPs. If of course this we will override this foreign agent law and the situation will get stabilized, we have this plan to contact with our colleagues in Moldova, for example, in Armenia, and make help them as well, and share our work with them, so that Georgia can lead even a regional network and regional initiatives for those countries as well. So this is one of the big plans that we have regarding tackling the SLAPPs. And regarding the national advocacy, you have already, while introducing me, you have mentioned that I'm a coordinator of the Anti-SLAPP platform. So this was established just 1 year ago. We are pretty much the child compared to the UK anti-SLAPP movement. And thanks to Charlie and Sarah, who were very helpful for us to provide some ideas and suggestions from the other countries' perspectives and European experience. We managed to draft a strategy, and we are looking forward to intensify our work in the platforms, which at this moment unites 8 national human rights organizations actively focusing on defending human rights defenders or journalists, and are actively working on media freedom and freedom of expression. And just last year, we have hosted first time the Anti-SLAPP Conference in Georgia, pretty much the similar that the Polish one. We have this plan to host the second conference and make it annual, actually, this year as well in June. Hopefully, we will manage to do it. And here, the Council of Europe was one of the great supporters to make this happen. Yes, so and regarding the yes, I wanted also to mention that we were actively engaged in this opportunity to provide our observation to the Council of Europe when they have published the draft recommendation in August, and we shared our suggestions and recommendations. And as far and I saw some reflections from our recommendations in the draft recommendation, which I think it's also one of the good example of international advocacy. And final, regarding the awareness raising, we are still starting to do it. We had some like media products, videos and posters and so on, and we plan to continue our efforts in order to raise the issue in a public. I think it's, I will now will stop and will be happy to to answer two questions. Thank you.
Thank you. Indrė, can you tell us a bit more about Lithuania? Because we've heard you just said that you already have some legislation in place, but you realize that it might be not enough and it would need to be amended. So could you tell us more about it?
Actually, these amendments are so specific, like, you know, that the problem is that if you want to prove that it's SLAPP, you need to hire a lawyer in order to participate in the process. So there is a, like, you know, initiative that the process should be so easy for everyone. Like, you know, you shouldn't, you know, invest a euro into this process, and you could do yourself, like, because the main, like, you know, argument now in Lithuania is that, you know, it's not enough, because, you know, anyway, you have to, you know, that defending yourself means that you have to have money. But again, I have to stress one thing, that again, I'm very proud of our community, that immediately we managed to raise money for everyone, for every journalist who is in a trouble. And we have a list of lawyers who help pro bono in these cases. And for example, this week is a happy week for journalists in Lithuania, because my colleague and I, we just won the defamation cases against one pro-Russian politician who simply, you know, he very easily uses every dirty wording for everyone who is, like, you know, he doesn't like. So we decided to go to the court. We were helped by the lawyers pro bono, and we won. So, like, this week, I mean, today I saw that that politician had to publicly deny what he said about my colleague. So, for example, on Monday I got 3,000 euros to my account from him. So it was like, wow, finally, you know, something happening, because we, like, you know, now in Lithuania you only have to have courage to get into the process, not to be afraid, because of course it's long and it's not nice, you know, but you can get every help. So those who would like to amend the civil code and civil process code, they want that you wouldn't need even a lawyer to fight against SLAPP. So it would be enough just, you know, to write an argument that you think that it's SLAPP, and the court should, you know, withdraw the case or analyze, like, you know, independently without that, you know, person who think that it's SLAPP. But from another point, like, you know, I also wonder how, you know, good Russians and Kremlin is in understanding and using our democratic institutions and democratic procedures for their means. Because now that, you know, SLAPP and anti-SLAPP is so popular in Lithuania that, you know, it's a good instrument, that anti-SLAPP, and all those, you know, well, like activists, pro-Russian activists, they react to the processes against them, like, listen, this is SLAPP. don't dare even start that, because this is SLAPP. Like, you know, they use all these democratic instruments, helping and defending journalists and NGOs for their means. So and now we raise that discussion again, that we will turn into the situation that all these procedures will be misused by like those activists who like, pro-Kremlin activists. I'm saying, and I can prove all my words. So yeah, that's the situation in Lithuania.
Poland.
So quickly moving to Poland. First of all, it's worth mentioning that we have anti-SLAPP working group for a few years already, which members are, among others, the organizers of this conference. And that's a good platform on which the talks about like how SLAPPs should be addressed in Poland started. In Poland, we have SLAPPs which are initiated both based on civil and criminal law. We have penalized defamation laws, but also usually some laws around assemblies are abused as well. Right now, at Helsinki Foundation, thanks to a generous support from Prague Civil Society Center, we are working on the project which is focused on the directions for legal changes, anti-SLAPP changes in the Polish law, which on one hand will at minimal level implement the directive, for which Poland will have now just 2 years for the implementation. But what we are aiming for, of course, is a protection that will really be able to counter SLAPP cases in Poland, which means that, first of all, addressing only the SLAPP cases with the transnational element is not enough, because the number of such cases in Poland is not so high. And on the other hand, the cases which are purely national are something that is prevailing at the moment. On the other hand, what has to be addressed is also the problem of the criminal law in Poland. So from what we can see, and for the project we did the focus interviews with the with prosecutors, with judges, with lawyers who are working on the SLAPP cases, and we have the group of experts, professors such as Professor Sadurski, Professor Łętowska, Professor Kardas, Dr. Wiercińska-Krużewska, and Professor Dziurda. So we are right now in this moment of working on the project. Some of the very preliminary findings will be presented tomorrow by Konrad, and the final product we will deliver by the end of June in the form of the policy paper. And what we hope for, because of course what we can do as the civil society organization is limited in the comparison to what the Ministry of Justice can do. So for example, organizing a huge consultations around the legal project to really know what the different groups that are, for which this is important, really need. It's something we cannot address, and we hope that Ministry will address it. But we can see some spots that need to be addressed, and we hope that together with the ministry, together with the other organizations, we will be able to push for real change that that will horizontally address the SLAPPs in Poland, and that the ministry won't stop just on the implementation of the directive. Thank you.
Thank you. So we have a couple of minutes left for questions. So we could, if someone could help me with.
Yes. Yeah. Thank you so much for this amazing panel, and thanks for organizers organizing the event. My question, it was not that simple to form it as in a formal question, but I have this, let's say, question still about the possible outcome which can be seen as the ideal outcome from your perspective of the anti-SLAPP action, let's say, because I understand that it's context-based, and it's really hard to say. For example, it depends on the country, it depends on a case, it depends on the context, generally speaking. But what will be the ideal outcome once for? Because as I understood, our movement is our action is always post factum. For example, we are from Georgian perspective speaking. We are doing our activities which are not suitable for the government. As Mariam said, most of the slappers are the government representatives. So they are doing something against us, then we respond. And we have in Georgia a public accountability problem. So for example, they sue us, we respond, it will be dismissed, the case, or we will be found guilty. But anyways, I'm just asking, I'm kind of pushing myself to get more out of this. For example, I'm doing activity, civic activism. I'm sued, and what next after the case? It doesn't matter I won or I lost. It's this is it. We are doing, this is the, let's say, our max, because in Georgia, if even we win the case, public figures will never pay for it. And the thing is that, okay, we are in this battle between them, with them, and we have this battle between us, and what's the point? Because I want to understand, I'm not criticizing, I just criticizing myself, because I have this feeling, that I'm not satisfied because we are wasting so much resources fighting them, and in the end they are keep going and they are doing what they've been doing before. And what will be the, let's say, ideal outcome of the individual case, or in, let's say, generally speaking? I don't have this direct, let's say, question to any of you. Feel free to answer if you have the answer. Thank you.
Perhaps let's collect more questions, if there are more questions.
Thanks. Thanks for this very insightful panel. Question to Indra. So basically, we're just actually keeping on the discussion that we had at lunch. While I was listening to you, I thought back of what the deputy minister said this morning about actually fighting the Homo Sovieticus mentality. So my question will be very straightforward. In your view, what's so special about the Lithuanian case? Because actually the situation that you described in terms of mobilization, in terms of support, in terms of also like legal provisions, was actually like an example that was completely different from other countries from the region. So actually I'm very, very much curious about hearing your thought about that. So why actually has Lithuania followed a different path, at least up to now? Thanks.
One more? Yeah.
Dzień dobry, Rafał Górski.
Rafał Górski. I have a question. How to encourage lawyers to work pro bono for such cases you have discussed?
What are the ways to encourage lawyers to work pro bono to defend such cases?
Who would like to answer the first question?
like, of course, it's very unimaginable to, would be unrealistic to say that we will be able to have any ideal outcomes as such. And I absolutely agree that very often we are very much reactive rather than proactive. And it is in Georgian case, the government, in some other countries, the business persons who start these SLAPP cases, and therefore we are in a defensive mode. I think that the solution is depends on a specific country's context again, and therefore it might differ country by country. I think that one of the most important things is to create an opposite chilling effect. What I mean here is to make those people that deter from further SLAPP cases. That we should create the environment where those people will not have any wish to do further wrongdoing in a society. And I think here this campaign, which, for example, the case coalition does, the so-called nomination anti-award or anti-nomination award ceremony, and generally naming and shaming could be one of the tools that we can do, which expose those the authors of the SLAPP cases and the SLAPP lawsuits, and therefore it might have some effect to some extent, of course. In a Georgian context, since I didn't have much time to reflect on the legal initiatives, I will take this chance to briefly address this part as well. That in Georgian context, I think that having a legal regulations, specific legal regulations regarding the SLAPPs will not have any specific use in a practice, because of the simple reason that even those laws that are really good are not applied properly by the judges, and all the laws are mainly abused by the government. Therefore, it is expected that even the anti-SLAPP laws will not be applied in a favor of the civil society, but rather than be abused by the government, maybe to call the SLAPP a real defamation case against the state officials or pro-government TV companies, for example. Therefore, like when we were speaking about the strategy in Georgian context, at the end of the last year, we decided that the legal to advocate legal regulations is not a priority at this moment for us because of those risks, high risk that we have. Just a small remark regarding the encouraging lawyers to work pro bono. Like I think it also depends on the it's also country based and. Depends on specific context. In Georgian context, since many NGOs are very much actively engaged in providing a free legal aid, there are less practices among law firms to take those actions. But we have an opposite problem, that many of those law firms are engaged in favor of the applicants and the plaintiffs. Therefore, the first priority what we have right now is not to encourage them to make a pro bono, but discourage them not to defend the plaintiffs. Thank you.
Thank you, and Indrė, over to you. Just three more minutes, and perhaps you could also answer the question on pro bono, because you had some good examples there.
I believe that, you know, in Lithuania and in Latvia and Estonia, the situation is more or less the same. If we talk about the societies, because really feeling direct threat from Russia, and mainstream media is one of the tools against Kremlin's influence, and that was I believe that it was that way before 2022, but after 2022 it's more or less obvious to all normal people in Lithuania. And that those pro-Kremlin organizations, which are quite active, we talked from 2018, and in all our 3 countries, they attack mainstream media, and they encourage people to not to trust mainstream media and to come to social media, to their channels. They you know, are simply, you know, like embraced by propaganda and disinformation, and there is no way out from there. So then so that's why I believe that, you know, there is like you can say there is like a bubble, you know, in that bubble society, but that bubble which believes that, you know, Russia is a threat is a big bubble, very big bubble, and probably bigger than in any other country. Maybe Poland could be a comparison, but Poland itself has its own very specific problems. Very authoritarian politicians, which who probably do not have direct links to Kremlin, but they have, like, you know, themselves authoritarian origins. We do not have, like, you know, local politicians that kind, but we have, you know, direct threat from Russia, and Russia acts through our politicians, and you can see that, you know, very kind of, you know, openly, and that's the difference of all of these 3 Baltic states from other region, from all our from the countries in the region. And now for pro bono, I think that publicity, because, you know, they earn publicity if they work pro bono for a good journalist. So yes, I mean he earns more later from the publicity, and it's like a, you know, a sign of honor to help, some kind of, you know, to fight against pro-Russian, for example, businessmen or pro-Russian organization.
Thank you. And one last quick comment from Susan.
Yeah, I just wanted to respond to the first question, because in the UK, I think certainly I agree with the response. You know, we want there to be a deterrent to slaps, but from my opinion, we want there to be a deterrent to complacency. And I don't know if I stressed it enough, but the UK, I think, has only really woken up post full-scale invasion into Ukraine to the issue of dirty money in the UK, and that's partly why SLAPPs became such prominent in the agenda. Right now, our National Crime Agency estimates that 100 billion is laundered in the UK every year. A number of cases that we work on is trying to expose that, but how many do we not know about? And when we talk about all of these countries and all of these contexts, what is the driving factor for authoritarianism and, you know, human rights violations and decline in democracy? Where is that money going? What is it being used for? So, you know, I think it's not just about SLAPPs, but it's about all of us, and making sure that we are aware, not just about what we know, but what we don't know as a result.
Do we have a second for one more question? I know Matthew wanted to ask one. Sorry for jeopardizing your plans. Yeah.
It's more a comment on the question about convincing lawyers to do pro bono work. We handle quite a few cases in Malta, and I'm really happy to say that we've never actually had to ask a single lawyer to ever do any work for free. There are so many funding opportunities that are available now to support legal work that we've just never had to ask for free services. And even with other media, what we've been able to do is set up a legal clinic with funding from UNESCO. There's the Global Media Freedom Defense Fund, and we've used that to keep a lawyer on retainer, and she's almost full-time handling these cases for different media organizations. There's client confidentiality with each one, so it's all fine. I mean, there are lots of organizations that have supported us as well, like ECPMF, Free Press Unlimited. But the first thing that journalists have to do is reach out to CASE or reach out to ECPMF, tell them about the lawsuit before you bring on a lawyer and make any discussions, or even if you already have a lawyer, most of the time we can find a way, you know, to cover the legal costs.
Thank you. Thank you, Matthew. And I think what also we mentioned many times here that it's a bit different at a local level, and I think it's our role to make sure that we raise awareness not only in capital cities but also to activists and journalists at a local level so that they know about this support available. Thank you so much for this discussion. And just a quick comment before the next panel. It will be held in Polish with English interpretation, so there are headphones available for everyone at the back. Thank you.
Board member of TV and Discovery, Mr. Aleksander Kutela, President of the Management Board of Ringier, and Mr. Bartosz Hojka, President of the Management Board of Agora.
Dziękuję bardzo za przedstawienie.
Thank you very much for introduction. You kind of stole the thunder from me, but we'll have a little bit more time to have a discussion. Therefore, I'd like to express my gratitude for introducing. Briefly, a word of introduction. I was thinking to myself, we'll be speaking mainly about history and what happened over the last 8 years, what kind of impact had the state, and we'll try to ask and answer the question whether state activities are kind of SLAPP forms. Our reality is surprising. Not only, the state's activities are not discontinued by the change of the power. Sometimes they are dangerous, and sometimes we need to think about them as pluralism stoppers in the media. With a hindsight, a few things that we realize, we remember, they show the impact of the state on the media and freedom of the media. We're going to speak about Poland, so in my introductory word I'm referring to Poland, but I believe that similar activities may be seen in the countries of the world. Over the recent years, what the state has done was to monopolize the public media. Public media are the tool wielded by the power more than a source of information. They no longer reel as a kind of social media that is defined in the act of on television and radios. Ruling parties, politicians found it pretty easy to air out negative opinions about free media and how media comment on the activities of the ruling party. This is what we are going to discuss. Negative public relations attempts to impose some legislation to staunch activities of free media. What happened, what was an alarming thing, was the regulator's positions change. So the regulator that should be responsible for managing the market is no longer a guardian of the market, but it's a guardian of the ruling party and delivers their policies, which is hugely dangerous. And this will be the pivot for our discussion to show how it happened. And we'll ask a question whether it's come to an end. Something that the state has done over the recent years was the interference in the private market. So the state became a player in the media market. Not only did it monopolize Polish national media, but they also took over local publishers of the press, like Polska Prasy and distributor of press and similar, that is Ruch, the chain of kiosks and outlets. The state interfered in the activities of the media. These were mass SLAPP court cases. These were politicians filing. So they wanted to interfere in freedom of speech. Freedom of speech is the basic principle that is the guiding beacon for the media. This was limited by mass court cases. Politicians filed suits whenever they disliked the way their activities were commented. What I said related to the attempts to introduce acts which resulted in the necessity to sell shares in one of the local media house, and therefore they wanted to limit the market presence, and they were doing this by introducing this act to limit the foreign shareholders' participation in the market. So let me speak about the speakers. This is the SLAPP conference. Why are you speaking about the role of the state? Why is this panel devoted to this very topic? And I'd like to start with a question that goes to Bartek. Bartek. There is a number of business and media activities. There are radio stations, printed media, portals, cinemas, publishers, book publishers. So you see every aspect and every facet of this market. So do you think the state activities can be believed as SLAPP? Does this definition suit? And if you could please tell us how it negatively impacts your business activity when we believe that these activities can be believed to be a SLAPP. Do they have any negative impact on the business activities of this company like yours?
Myślę, że regulator.
I believe that regulators acting on behalf of a populist or authoritarian authority tries to force media to be obedient using a wide portfolio of measures and actions which resembles SLAPP in such a way that they serve the same purpose, simply to limit the independence of media, to stop media from observing the authority, but to use, to make media applaud the authority over and over again. There are lots of similarities in this respect. However, there is one based on many years of our experience. We can say that there is a fundamental difference. Compared to SLAPPs, the range of instruments that public administration can use is like nuclear power due to several reasons. First and foremost, the regulator is both the persecutor and the judge. The first instance is typically the same institution that issued the decision, because the potential sanctions have the power of a nuclear weapon, starting from severe financial penalties imposed by many regulators. More often than not, this is a high. These are amounts which amount to high percentage of the annual turnover, and this means tremendous costs. Through to various decisions related to licenses, the possibility to instigate proceeding, and this exerts huge pressure on the broadcaster or media house. For instance, like the company which I represent, this is a stock exchange listed company. Even such a risk is a very strong signal to the capital market and our investors that there is something wrong going on around the company. This means the threat of not extending the license. We'll definitely mention it throughout today's discussion. It is also about the decision that affects the company's competitive advantage. Agora was subject to proceedings where we were banned to take over Radio Z. We had to fight for this approval during 4 years battle in the court, and 2 instances were necessary to win the case. We lost a lot of time and a lot of money. Last but not least, the measure of such opportunities of administrative bodies and regulators representing populistic authority is that the nuclear weapon. I'm sorry, something went wrong with the microphone. We cannot hear the speaker. the regulator's activities have significant burden because of the decisions they make and also those that they don't make. Recently, we have observed a lot of pressure on independent radio and television broadcasters involving prolonged license granting proceedings. It was related to TVN, Warner Bros. Discovery, and Radio Talk FM, owned by Agora Group. These are only a few examples. More will definitely come throughout the discussion. This is not an exhaustive list. I simply want to say that there are myriads of opportunities and that this is a sophisticated type of pressure. We cannot say that Poland is the country where journalists are sent to prison. But at the same time, I feel that over recent years, we have experienced tremendous pressure as independent media. It was exerted through different measures, undermining economic and business fundamentals of our operation. It's obvious that without financial independence, it's not possible to defend the independence of journalists and editors' offices. Anybody willing to refer to this part of our discussion before I move on? That's the essence of the case. Is it SLAPP? That's a form of SLAPP which is actually most dangerous. It means focusing on destroying the media. This is a concerted and strategic activity to destroy the essence of what free media is. We can say, well, you have survived. The bright side of the story is that we started to cooperate more because we understood that the values behind our offices, journalists, and publications bring us stronger together than competition. In my opinion, the regulators' pressure, we can ask who regulates the regulator. The regulator should be regulated, controlled by the law. Do we see it nowadays? Anybody who observes what has been happening in Poland, for example, on how the president of the National Broadcasting Council will answer no. For the president of the Polish Broadcasting Council, law does not mean much. Hence the hazard, and hence, despite the constitutional provision of the freedom of media in Poland, this is our major concern, how to get over a situation in which a single body, meaning Polish Broadcasting Council, thinks they have the right to say what is right and what is wrong, because in its political interest, it's even more important than what objective media tries to disseminate. Professor, you would like to refer to what the speakers have just mentioned. We can clearly see that such state activities affect financial business operation, but first and foremost, when it comes to media, they greatly affect the independence of journalists. It is about not experiencing the pressure that does not result from law. Our regulations nowadays, unfortunately, allow for it. There are no regulations that would allow for preventing such activities and such influences. Professor, would you like to refer to it? Well, I wouldn't like to be the bad guy here, but the Polish Broadcasting Council has not been established to use SLAPPs. Mr. Hojka rightly pointed out that the operation of this regulatory body derives from the nature of the ruling, from the authority. For some time, we had what we call monopower. It applied to all state institutions, including the president. Consequently, the Broadcasting Council, instead of pursuing its objective formulated in Article 2013 of the institution, which states that the Polish Broadcasting Council has been established to guard public interest and freedom of speech. For some time, it was quite uniform to pursue one political party's goals. That's why there is a broad discussion on understanding SLAPP, whose consequences mean the so-called cooling effect. There is one more instrument that has not been mentioned. If the authority does not like someone, they deprive them of the revenues from commercials, especially by state treasury companies. This is a kind of sanctions you can impose. Coming back to the Polish Broadcasting Council, over the last 30 years, in December it's going to celebrate its 32nd anniversary. There were different stories. However, that was quite a pluralistic body. People could not agree with one another, but simply wanted to strike consensus. There was a practice, because we have Article 18 that offers lots of opportunities to interfere into the content that does not live up to the standards set out in the article. It's about some swearing speech and protecting the youngest ones. There was a procedure which stated that before a decision about imposing a punishment is made, there was an ongoing discussion in the pluralistic group on whether such punishment is justified. Then the resolution was passed, or there was no resolution at all, but the direction of the discussion provided some context. Based on my experience, I can also say that the lawsuit chances were discussed. Typically, when a punishment is imposed, the broadcaster can appeal against it. That's why case law and practice was analyzed whether defense is possible. The point was not to invest state money into a lengthy lawsuit. We have a recent example. TVN, after 10 years, was punished because of Anna Maria Wesołowska show. So this is an example of long-lasting activity involving huge efforts and resources. The practice has changed. I opposed, but the majority of the council approved. Now the president interprets the procedures as their exclusive prerogative of administrative procedure, and the others learn about the results once the decision has been made. There is no exchange of arguments, no discussion, no presenting the viewpoints, but this is a one-man's decision. Then it is court-controlled. However, considering how lengthy the process is, in the very case 10 years, it's unbelievable. Only quite recently have I received documentation related to appealing against a penalty. The documentation was so abundant that it was submitted on a flash disk. So many documents. I wondered how much it costs to develop such documentation, contents, analysis of case law, expert opinions. These are huge costs that nobody will pay back, even if it turns out that the fine was unduly imposed. Not the whole amount will be refunded. Sooner or later, I suppose it's going to happen. Some amendments to the law on radio and television broadcasting will be implemented. We have quite imprecise statements such as raison d'etat. There is no definition of what it is. Who can state whether the president of the National Broadcasting Council can define what the raison d'etat is? I seriously doubt whether the president of the council has such a right, considering how lengthy the proceedings can be. And this is the result of some reforms of the judiciary system in Poland. We should make some provisions more detailed, more precise, and the same applies to various authorizations. Such penalties, in my opinion, should be preceded by a resolution based on a consensus of a group representing different viewpoints. One more thing to make. The Polish Broadcasting Council has issued its opinions on Article 212. In previous years, they were for basing it on the civil code and not penal code. So that's it for the legal aspect. Mr. Frąckowiak, I would like to add 2 words on the sanctions and onerous situations that the professor referred to, meaning the cooling effect and Article 212. Very often we hear that not punishing, but the process leading to it has the cooling effect. It's simply visiting the court over and over again or consulting psychiatrists. The same applies to other regulators. Bartosz mentioned high fines. That's the final consequence. However, we also need to remember the process of investigating. We as Izba Wydawców Prasy have experienced it several times. A few years ago, after the Ruch lawsuit involving the Chamber of Press publishers, were controlled whether there were not the cases of collusions. And it was also about the quality of contacts with the press publishers. It required involving efforts, costs, and people to answer questions. And it was only explanatory proceedings, not penal one or not a real lawsuit. However, at the very stage, it was threatened with sanctions for providing incorrect, untrue information. And this is the threat of a sanction. How is it treated? I learned about it in the case of similar proceedings. The same office requested some publishers on explaining the case of some wrongly marked supplements. We proposed that, understanding the problem, we should try to develop a kind of code to have clear rules for the future on what it's going to look like. And the bureau was not really interested in it. However, they said they had some other publishers to consult. So the point is, first, we'll try to punish you, and perhaps in the future we'll come back to how to regulate the market and state the or stipulate standards. Self-regulation, that's the topic I would like to come back to. Let me switch to another topic. We started discussing the regulators' actions and roles, as well as considering what SLAPP is. We know how onerous, how costly and destabilizing such activities can be for companies and for editors' houses. It's not only about the regulators, because the state can treat media publishers in different ways, even if they are not subject to such regulators as the National Broadcasting Council.
As we heard before, the state that wants to subjectify media has got a plethora of tools to exert pressure. We discussed legal measures used. Let me give you the example of our publishing house. We are not regulated as much as televisions are. Institutions associated with state-owned company, there were 350 suits that were filed. So you can imagine time and energy for such lawsuits, response, not to mention the fact that journalists and managers have to go to court. This destabilizes the company's business operations. And another thing, economic measures. We are one of the biggest publishers in Poland, so we should be awarded advertising contracts from state-owned companies. There was a huge decline past 2015, and it's got an impact. If this is millions of złotych, dozens of jobs for journalists that we can sustain or give people a sack. So these are the results. The attacks utilized public media and always to discredit the credibility of the media. It was insult, the use of language that skipped all the standards of democratic state. Our media, our journalists were abused. The abuse was hurled at them. They said that they are media that represent interests of other countries. They were blackmailed. Public television programs, public media programs that attacked journalists, media, our families, our publishers. This is our joint experience. And what you mentioned here is also on the list, like new payments and new taxes. We all remember the protests that brought media together when they were protesting against the tax that would support a number of institutions. A few percent of marketing turnover, advertising turnover would make it difficult to break even and stay afloat. Some of the activities can be managed. What we have faced over the last few years was that it was omnipresent and ubiquitous. You started your working day and you started scratching your head. What happens today? What to defend now? How to defend our journalists and our staff? Legal department, should they do what they normally do, or should they respond to cases and letters? And there were dozens of them. Smaller organizations are in danger of being paralyzed. Michał may contribute to that. It's difficult to defend yourself against these kind of activities because there is charge, allegations. It's not true. Like, for example, collaboration with foreign superpowers like Russia. And they use legal tools. Attack was followed by another attack. Michał, remember these cases? Yes, it did happen. We were quite brave in responding to these hits and punches. We live because of the freedom of speech. We are open to criticism. We are not complaining. We are not exempt for that. We do not want to have a position that is criticism-free, even if this criticism is unjustified and harsh. But there was a sponsored, ferocious attack from state institutions, and the attacks were synchronized and harmonized from many places, simultaneous. They said there were allegations that we represent interests of other countries, that we are traitors, we are not Poles. And this Polish raison d'etat, which was quite blurry and undefined in the previous period. This is our experience. Life coaches say, don't complain, say thank you. So me, being the head of the newsroom on TVN and Discovery, I should say thank you for what we have been able to defend. There was solidarity of civic milieus and journalistic milieus, international public opinion, and the attack that was targeted at us. They wanted to staunch the independent voice. It was exemplified by Lex TVN Act. Professor, if you got the file with the materials that you have had to produce in response, hard to imagine. And we should thank for many other things, not only Lex TVN Act, but also support in TVN24 concession. Dozens or so months waiting. It's the biggest information television in Poland. And all of a sudden, you discover that this entity, this organization that brings together lots of people, is questioned. We got our concession 3 days before the deadline. So what kind of institution is able to sustain this kind of pressure and things? We managed. We are strong. We are supported by our owners. We were convinced that we were right, that TVN needs to be broadcasted from Poland because this is a Polish TV station with Polish throbbing hearts. And then fines, inopportune fines that we mentioned all here. They were usurpers in their thinking that the head of the Office of Broadcasting Corporation, Broadcasting Council, administers the fines single-handedly, with disrespect to the basic rule of law, against what he was appointed to, because the broadcasting board should safeguard the freedom of the media. This is what they have been created for, not to pressure and staunch and to be like a czar exercising their powers. It's a good question, a good point for a question. So where is the thin red line between justified and unjustified interference of a regulator and legal abuse? We've got law. We've got legal regulations that are abused. They have been abused because there was one center of power. One party wielded all the power and controlled the regulator. But not only that. We have had the change of power, but still we haven't got rid of the problem. Sometimes this regulators' rights are too extensive. They violate rights, they abuse the rights. I might be naive, but I believe in procedures, if you will. What we are harvesting now is painful experience. So the new bill might limit the competences that now are attached to one person. No way out. Never before have we had this kind of experience before. Of course, there were instances, previous heads of the broadcasting board imposed fines, but it was preceded by a discussion. There was an exchange of opinions. Today's experience shows that these are excessive competences vis-à-vis the situation that we have. You design law for difficult times. We used to live in good times, now we live in bad times, and it is time to draw conclusions from these experiences. A lengthy concession process is what you mentioned. There was this proposal submitted by late Iwona Śledzińska-Katarasińska. When a concession is not admitted 90 days before the deadline, it is given an ex officio. And many strange things happen when there are concessions. Like, for example, different times. I oppose that, saying to others that concession can be withdrawn if you no longer want to be in business. And 10-year period is quite obvious. You plan business in 10-year perspective and different in 3-year perspective without knowing whether you'll renew concession in 3 years' time. We need to have the lesson learned from the experiences. In an ideal world, there are certain rules and regulations. There was the head of the International Journalist Organization. And she said, it's not that journalists are deprived of responsibility. There are abuses in communication. There's patter streaming, for example, that should be subject of proceedings. It impacts young people. But there are certain phenomena that are bad in communication. They should be counteracted. But you need to have common sense. I'm a proponent of this collaboration model, where a regulator is a participant of the market and a partner to the organizations that operate in the market. And the market is getting more and more difficult. You understand it. There's huge competition, and this is a rat race every day to stay afloat. I like this British concept, the arm's length. So there's a prospective danger that they step in if they don't agree with the environment, that the specific business does not agree and does not infringe other interests. It's difficult to delineate. It's learning by doing, as a matter of fact. And today's practice, today's learning by doing, is far from the ideal situation. I said it publicly, and let me reverberate it. This body is unable to assess the public interest in this composition. Political words should reflect. I don't know what they will do, but something needs to be done. Public interest is the notion that should be interpreted diligently and with prudence. Now, the situation acts to the detriment of the public, private, and media market. So, for example, subscription and money is not transferred to public media, and media do not support the realization of the tasks of the media. It is in the account, millions of zlotys that cannot be used because there is one person's decision. So these are the problems that we are discussing. In the ideal world, you need to see what happens in practice. You should adjust to the situation, you should draw conclusions, accept solutions that provide for a better market state and relations between a regulator and the market. I believed in soft instruments like discussions, conferences, meetings, and panels, exchange of opinions, not only financial sanctions. Sometimes we need to have sanctions, but not always. The council, the board, imposes fines for advertisements, like, for example, alcohol outside this time scope, exceeded time limit. Quite obvious. When we speak about freedom of speech, freedom to air out your opinions, these cars should be very prudent. Bartek, if you can speak about this. What we've noticed recently is a dangerous interference of the regulator into journalists' activities. So this is the competence of a court. So you can take to court the editor-in-chief or a journalist when there's an infringement to diligence. And we've got the board that says, dear journalist, we'll tell you that you infringe diligence. So we'll impose the fine. Not us. Me. Because these are decisions of president of the board, Mr. Świrski, and the board, as Professor said, learned once the fines are imposed. There is the line, the division line that you were asking, because what is permitted and not permitted. Interference of regulators into freedom of journalists' activities. Mr. Świrski makes decisions to impose fines, and he refers to the article Professor mentioned, Article 18 on the Act of Radio and Television. It's a long one, but it refers to content against Polish Reason d'Etat or hate speech propagation, dissemination. Mr. Świrski uses this as a pretext and extends it and expands it. Mr. Świrski imposes unjustified fines. Of course, we appeal to the court. It was the Radio Z case. And most strange examples. Talk FM, one fine for alleged propagation of hate speech. It was a journalist who quoted the textbook of history and reality school subject. Radio Z was fined for informing that President Zelensky was in Poland and it was not in agreement with the Polish services. And it was the information from these services. He believed this untrue. So he usurps the right to say what is given in the media is true, what is not. Interestingly enough, where does he know that? In the proceedings we learned that he took an extra mile to ask the Ministry of Interior Administration whether they have knowledge and got no answer. Article 18, no reference to disinformation. The article does not say what is the right to impose fines. In my opinion, this division line is here. When an officer that has been politically appointed interferes into the content of press materials. This is breaking this line of division. What is right, what is wrong. And diligence of journalists. Michał, do you want to comment? mission of public media and commercial media. The board has got a different relation to public and private media. Public media have a mission that is precisely described when we refer to press law provisions, and they try to impose their opinion and try to find the media, and there are certain processes to check whether the media is robust and reliable. Of course, we create different answers. We prepare this. It's time-consuming for lawyers and editorial houses and editorial teams. But this procedure is like a witch hunt, more of. And this court is a court we never know what is the answer. Piotr Świerczek, Smoleńsk film, The Power of Lies, and Świerczek was attacked because he charged the very center of peace, law and justice. Świerczek tried to explain meanders of a catastrophe, and Świrski said, "I'll tell you what is the true."
We have been discussing it, investigating and discussing various risks related to confidential documents, the information not available in the public domain. And we revealed some aspects of the Smoleńsk subcommission. We produced a number of analyses and letters in defense. The president also ordered various expert opinions on the subject matter, and nothing happened. It went in vain. It vanished into thin air. A year and a half has passed, more or less. Professor, we do know what it looks like from the legal point of view. They say it's against the raison d'etat, and the cases never end. We produce a lot. We've got fact, 2 information broadcasting channels, and lots of stories about Polish reality shared every day. We've got some visitors to our studio. Professor Engelking talked about ghetto uprising, and it's also wrong, and there are expert opinions on it. A year passes, we know nothing what's going on about it. And we have to analyze it, we have to consider it. Media are not holy cows, and we are fully aware of the responsibility that our power entails. We have the privilege to talk to people. People listen to us and they believe us. We feel the burden of responsibility. But it must not be like that, that a single person, because of ideology, says they would control the market, that that particular individual is the measure of everything. Even at the family table, there is not a single person who is always right. And here we've got a person who knows about Smolensk disaster, Krakow diocese. It's unbelievable, but it's actually going on. And the person also knows a lot about secrets about extermination of Jews during the Second World War. One more thing, I cannot give up on such an opportunity. I can see some lawyers who exchange communication with us every day. We had around 100 claims or complaints, not the major ones you can read about on the media. We get complaints every day. On the website of the Broadcasting Council, there is an applet for viewers. They can submit their complaints. The Polish Broadcasting Council, according to law, should find out what the complaint is about, but actually they don't. And we get formal letters from the legal office from the Polish Broadcasting Council that in your footage about labor without painkillers, it's disgusting and it's about some intimate issues. We've got such complaints every day. For instance, that females demonstrating because of the tribunal's statement is pro-Kremlin and pro-Banderas. And we get such complaints. I quoted from my memory, but if we wanted to publish it, Szkło Kontaktowe, which is a TV program criticizing the reality, would definitely lose the competition with such letters. Should we really ask journalists, is it manipulated? Is there something behind it? That's a lot. It's harassing media at every level. I don't know if it applies to all electronic media, but I feel it's related to the fact that since we closely observe the authority, we are not the good ones, and the authority officers understand their mission in such a way that's pathological. This is something we must definitely contradict. The conference like today's, the ideas which you share can also lead to it. We need to feel this is our battle that has not ended, contrary to some optimistic slogans we heard after the election. It's not a bed of roses, and it won't be unless we take care of it ourselves. So I suppose that's the appeal, calling for cooperation. You have mentioned that recent years made market competitors combat the abuse of law. That's what I would like to investigate. Do you have any ideas how to work together without violating the law, but on the other hand, to be able to influence regulations and the executive power? Because we know that their activities during the previous rule was quite onerous. We said that the authorities take different actions and measures. We also need to respond in a versatile way. There is not a single response that would defend us. Cooperation is pivotal. I would like to leave behind all these arguments because of a fundamental reason. When we take a step back, we can see that we have survived the turmoil, but there's one consequence. After this period, the trust in media has deteriorated. This applies to social media. The general global trend is the trust in media has dropped. The activities we mentioned contributed to it, and we paid high price for it, and it's really hard to win the situation back. If we try to regain our position, it's possible only through cooperation, through speaking with one voice. It's a strenuous task. There are some spectacular activities, such as media protests, attempting to implement taxes. There are some organizations where we unite our forces and try to speak one voice to defend media independence. We make such efforts. It's good to see them. But if we are to look for some positive aspects, Michał, I would like to say I love your attitude. The positive thing is that the media understand they have shared mission to pursue. We have implemented and taken a number of actions to defend from the endeavors. But the question is, will we be able to reverse the trend of media losing their losing people's trust. So now I would like to refer to the reliability of media. We've got the attack on media, but media need to fight for their reliability. That's true. So the question is whether such a cooperation really makes sense. Some answers have already been shared. From my personal perspective, I could say it's obvious. My work is meaningful and it's interesting. It's really meaningful. In all cases where we have battles between regulators and publishers, always the stronger one oppresses the weaker one. In the case of individual journalists or publishing houses, one lawsuit is enough to damage someone's career or to close a publishing house. In the case of large media or large publishers like those we have here, it's more difficult, but there is a way to do it. One lost case won't damage Agora or Discovery. However, if there are many such lawsuits, we never know. If there are 100 lawsuits and many interventions, at a certain point in time, even if the publishing house is not damaged, it's significantly weakened. Cooperation is the method to combat and prevent such situations. Our chamber shows that it's not about dealing with individuals, but with the whole sector. That there are some legal mechanisms which, especially for individuals, can be extremely helpful when it comes to counseling in very special cases. There are some common efforts going beyond organizations, like in the case of Lex TVN. We could see a lot of people and all publishers involving in the case, which was finally successful. On a daily basis, organizations use such mechanisms. Let's put a fly in the ointment. In order to make it work, we need to have many representatives. Not all publishers are aware of it. The most challenging question that is often asked by publishers is, what do you do in the press publishers chamber? And the simplest answer is, we do everything which is related to publishers, businesses, and operation. But such awareness is not sufficient. The same applies to the awareness of those who work with us, that the flow of information, exchange of information, and informing about problems is very important. We need to know about them as early as possible. It's a simple and convenient mechanism, because such organizations have their statutory provisions, which can become shields in such situation. We need to remember that these are tools. Every organization, every institution is a tool to be used by publishers, and it really works if you remember it. We're coming to an end, so I would like you to wrap up, but it's going to be oriented. We've got some EU initiatives aimed to implement some legal regulations related to media freedom in all member states. Do you think that's the right direction, that the EU should have the prerogative to influence media market pluralism? I suppose that's the right direction to follow. Over the last years, we've been looking for support since we were the subject of unlawful and unfair actions of regulators. or the state's administrative structures. We've been seeking for support in the EU institutions, and the answer was, sorry, we have no instruments we could use. So it seems that the Media Freedom Act is the attempt to implement some instruments. They are not far-fetched. I would rather call them instructions, but I feel more secure knowing that if the European Union can exert more impact on national regulators with our experience from previous years, I feel more secure having such a perspective that someone at the European Union could regulate the regulators as postulated by Michał at the very beginning of our discussion. I also feel that, though I know I sound controversial, because broadcasters are not keen on over-regulated media market situations. Not everybody is enthusiastic hearing about another regulating institution, one more tier or level at which media is going to be regulated. Remembering our experience, I feel more secure. The foundation of media freedom is their financial independence. The very fact that we managed to survive, we owe to our financial independence. It would be good if such regulations, if created, dealt first and foremost with guaranteeing the fair use of our content. In the AI times, if the media do not get decent money for the content they produce, this is a fundamental threat for the future of media. It would be good for the regulations to focus on the fundamental issue, and then I would definitely say yes. I am not optimistic in this case. The assumption is that the European Union is the community of values. Our everyday activity is supported by a catalogue of values, hence we should defend them. Fico in Slovakia, you know what happened yesterday. We know what's going on in Hungary. We can expect in every place, and I also mean the so-called old member states, that will have to defend these values. Every instance that could support us with any type of tool would be more than welcome. Well, it's all happening here and now. One day, huge corporation like TVN could cease to exist because of some things happening here, and EU could do nothing about it. I'm afraid that if we forget the essence of the civic community, but nothing could help us, we could save ourselves, and we should build a walls protecting us against the empire of evil. We feel we are the happiest country in the world. We've got the border with Ukraine, where there is war with Russia, but the war is not here. Everything that attacks journalists and freedom of media are the activities in favor or to the benefit of the dark power behind our border. We need to treat it very seriously and remember that it is all inspired, and I'm not attacking any political party. We need to be aware that everything that tries to destroy the foundation of democracy is played by that system. We need to contradict it. There is a long way ahead of us in this respect. Thank you. I am more skeptical when it comes to EU regulations than Bartek. I do appreciate that we've been saved by the possibility to refer to the EU when it comes to the situation in Poland. It's invaluable. However, we need to be cautious. It's easy to over-regulate at every level. I am a bit worried in the context of this act. It's good that we'll have someone supervising our regulators, but on the other hand, all of a sudden, our national regulators get extra legitimacy towards the press. It's obvious that in addition to some issues related to public media, the press is not subjected to any state regulations. And all of a sudden, owing to an initiative caused or resulting from good reasons, our Broadcasting Council will have the power over the entire press. I like some statements which emphasize that we ask for more freedom of regulation and more regulation of freedom. We know how to handle it, but there are some directions towards which activities regulating freedom of press and freedom of media should go.
First and foremost, the freedom. And in Poland, we've got excellent examples of self-regulation in place. We spoke about this briefly, starting with the ethical charter of the media that was safeguarded by Board of Ethics of the Media. It's weaker, I mean, the institutions, but journalists are to blame. And advertisement board and our own code of press publishers. Does it work? May vary in your opinions, but if it is treated seriously by the milieus, it will work. And it's example of our host. We were working long on the code's provisions. Everybody wouldn't like to have troublesome ties that you imposed on yourself. Agora didn't want this to be so strong, so harsh. But once it was accepted, there was work with journalists and publishers and staff at Agora to implement this document. It was an excellent document, an excellent example for me. We self-imposed regulations, and we worked hard on these regulations to be operational. It's a basic thing, self-regulation, not regulation or over-regulation. And the second thing, I repeat that, what Janek was speaking about. Media freedom, publishers' freedom, is rooted in their economic position, whether they are strong, whether they've got power to defend the freedom of speech. And speaking about European Union acts, I'd like to be supported by good regulations like DSA, DSAM, implementation of this related rights directive. When we struggle with exemptions and other things that weaken the position of local editors, but for this would have been stronger. We wouldn't have to any decrees that describe freedom, would provide for freedom ourselves. I'm the oldest person here. Don't regulate your receivers when we speak about regulations. That was a slogan in the past. We don't have it now. But the board's rights will increase. It will become the part of the European Council. We've got some time before this act is implemented. We need to remember that the environment changes, media consumption patterns change. All media are digital today, or they have digital equivalents. Even the press is printed, they've got the digital version. So there's the change of the world that we need to accommodate. Speaking about the European Council, it's a positive element. This regulatory body, Polish board, will become a part of the European system, which is important. MS mentioned here, 1 to 27, he lost. He was voted out because he was only person against EMFA, this European Act on freedom of the media, and he'll become a part of the Council at the European level. Strange. This role will be changing, but I think that every publisher will feel safe, because when we have regulations, the regulations will be robust. And you cannot make decisions at your own convenience. Regulation is one thing, but media education is more important in the future. You speak about losing credibility, but this is associated with the fact that we should recover media's credibility in a broader sense, because we've got informed users, because the general public is more and more polarized. And polarization is best evidenced by what you know. TVP Info lost 260,000 of viewers in 15-second slots. People switch to other media. They don't accept this if it is not dividing message. That's the message that does not polarize. They may return in some time, but there are no new ones. So it shows polarization, and there are consumption patterns that changed. Some people don't use the media of this type, or they gave up on public media, many things. I agree with you. The rights to use the creation, proprietary rights, and European aspect, that is very important. Big companies, big platforms will be the subject of control that we don't have now. They do whatever they wish, and we are controlled by algorithms. We should put an end to it. Algorithm can be checked. Pluralism test will be performed. Many things have not been made precise. And what we are in for is an interesting future. The reality changes. We cannot stick to the model that was right for analog period that is being weaker and weaker. Still, we are surrounded by it, and but it becomes the thing of the past. Thank you very much. It's a contribution to have another conference or another panel, how to cope with the future with the ever-changing media, and what's the role of the state in this new technology of the media. Thank you, gentlemen. It was a pleasure. Of course, questions from the audience. Sorry. Dominika Bychawska-Sinialska, thank you very much for this interesting panel. We've got publishers, and on behalf of the Polish Anti-SLAPP Working Group, I'd like to ask for openness to share data. We've heard about a crazy number of court cases that you're a subject of. We try to document them, so being open, sharing the data with us is important for us. So this is our request. I was overjoyed to hear about this solidarity and then the last straw that broke the camel. I was a lawyer at Helsinki Foundation. I've requested the change of Article 18. Together with Talk FM back in 2010, we started the discussion about this. I'm very happy that we are about to cope with this, but solidarity is more than advised. I'd like to refer to what Professor Kowalski said. We should start working on the Media Act. Not only public media should be discussed, we should discuss the article, and let's make the best of the situation, and let's try to discuss the unjustified and excessive fines in front of European Court. One of the televisions is not present here. It was the case in 2018. They almost filed a complaint. If we had done it, we would have had the court's ruling, so the paper that could be used to lobby for a change. Thank you very much. Krzysztof Głobiński, Association of Journalists. Thank you very much for this interesting panel that made it possible to look into the souls of publishers, because sometimes you've got the feeling that publishers have no soul. Now I know you have. I'd like to thank for supporting MFA. Some kind of support. And the composition that we have here, we've got MFA, and it should be implemented now. What is also interesting, those who were against, now you turn to European Commission and Union for help to be protected against Meta and Google that may destroy you. You didn't want to have this regulation, and now you request the Commission to help you. One more thing. Oko Press publications, the recent ones. Some publishers, as Adam was saying, about collaboration, not publishers, did not exercise this solidarity when it comes to the attitude towards those in power. And RMF and Polsat, the powers kind of bottom in. Press release forums. Did you have any conversation? Have you had? Will you have a conversation? What was that behavior? The ethic code. Is it? Should we carry on? My request is, and it is a strong request, not put an equal sign between expenditures from advertisements and believing that we are subjectivized to advertisers, because it would be very dangerous. And that's it. If you allow me, Alek, follow up to the question. Thank you very much for this question. I'd like to say, in recent years, and populists that were in the power, the ones that we struggled with being independent media, they were unprecedented in bringing the milieux together. Never before have we seen this solidarity, especially when they are trying to introduce new legislation like this media tax that would sell us sprawling to the ground, when we had black screens of disease, black covers, Lex TVN, that were to do away with the media with the greatest outreach in Poland. Unprecedented manifestation of our business sector's unity. Normally, we are competitive. Not only do we compete with Google and Meta to capture the attention of readers and listeners and viewers, we also compete on a domestic market between each other. It cannot go unnoticed that efficiency is also measured when it comes to the tools that are used by the populist when they want to make life difficult for independent media. Not all the media were independent. Even big players, not only the small ones, that Mr. Frąckowiak was speaking about, not only the small ones, well, one administrative decisions is a death sentence, but also the big ones and big broadcasters who were trying to make a rapport with those in power to carry on working. An interest in other markets related or other business sectors. So there's one more leverage of those in power to impose something on those working in our business sector. This chilling effect, freezing effect, is not theoretical. We could observe it with the naked eye. It was happening in front of us. I'm very proud because many times we acted together, united, efficient. And there was almost a deadly situation that we defended ourselves twice. It's a basic thing. Big global organizations that use the contents created by journalists, that are co-created by publishers. We organize the process. If they use the content, they should share the income generated on the content. If the value chain has got one beneficiary, the dominant in the form of global platforms, there'll be not enough people creating the content. So we need to realize this in order to finance the things that we are speaking about, like investigative journalists, to send our journalists to war in Ukraine. These things do not self-finance. We are media representatives. We co-finance these kind of activities. We do it because this is our mission. We are socially responsible. If we want to finance that, we need to be sure that somebody uses the content and they share the income with us. It's a basic thing. It's to the interest of the broadly defined environment. There was this question. It was a provocative question. I criticize European Union in some activities and support it in others. No. We gave the answer. We want to regulate or support, I prefer the word support activities Alek was speaking about, the ones that are needed and advantageous for the media and freedom of speech, without impeding their activities with over-regulation, whenever over-regulation is harmful. It's a regular process. And the same applies to publishers of various kinds. Should we introduce some discipline against those who had a different opinion, who supported a different government? I'm happy that we've got the country of freedom of speech with different publishers. Agora and Polityka on one hand, and Frate and Gazeta Polska on the other. We try to cope with things that are important for the whole market. One publisher supports this government and the other supports some other government. That's their right. We should take care of this happening in accordance with rules and principles, ethics, with observance of the role of the media in a democratic country. Opinions may differ. This is the measure of our success too. I need to refer to that. We are very happy with pluralism. There is richness of media offer in Poland. We are beneficiaries and parts of this, but you cannot equal those who observe the values of journalists and those who clap to those who want to destroy this profession, like it was the case for us, ATS. I understand you. You have collaborated with different publishing cruising houses, but those in power who wanted to do away with freedom of media, what democracy is, supporting it and getting things as bites. It was not market participation, quite contrary. We had small publishing houses that got millions for what they were doing. That was the problem. I agree with that. It was the basis. And at the end of the day, I said about diligence, freedoms of speech, principles, dignity. Our chamber and other organizations, national, local ones, we never had doubts of this kind, as evidenced by Lex TVN activities. It's education, it's a guideline for those who do not follow the principles. Filip Gołębiewski, Institute of Discourse and Dialogue, thank you for this interesting panel. I agree with the conclusions when it comes to abuse of Article 18 by the Broadcasting Board.
I would like to ask about your opinion whether media independence that you are fighting for, that you postulate for, guarantees reliability of communication disseminated to citizens. We want our citizens to get reliable content, assuming the ideal showcase situation you postulate for. Is it a guarantee of reliability of content? The self-control mentioned by Mr. Frąckowiak, is it only possible based on some ethical rules of decency? It's purely theoretical, and I would say no. We cannot guarantee independence of quality. We need to have independence and choice. You can be independent, but not competitive. However, in order to sum up what we have discussed, and from the regulator's perspective, I can say that it's worth talking to the market representatives. That's the philosophy that every regulator should be driven by, to talk to the market representatives, not to be afraid of it, and look for reasonable solutions. The reality is changing very fast, and it really requires exchange of opinions. It's not about a person sitting behind the desk and interpreting regulations on their own. Answering your question, purely theoretically, there are more conditions than only independence. Bartek, I simply want to say that there are some control mechanisms resulting from the press law, and you can either protect your personal rights, and there are mechanisms that have been functioning for many years now. They are appropriate to control what you have just mentioned. That's the first thing, and nobody protests against it or opposes it. Michał emphasized that we are not holy cows, that media make mistakes, and that very often we deserve criticism. Independent media, do they guarantee 100% access to reliable, professional, top-quality information? No, but it's like with democracy. I have no idea, and I cannot think of a system that would be better than the one we propose. 8 years of challenging experiences, greasing the power's palm was some media's way to cope with that over the last years. There were many big corporations in our market trying to get on well with the authorities, but there were also other ones that defended their independence. I may not sound humble, but we contributed to what happened in Poland in October last year. Poland is an example that you can reverse from the populistic road, that there is a way back. In Poland, we have succeeded, and in Hungary, people have not succeeded, and the system of independent media has been dismantled. It was dismantled many years ago. There are many ways to maintain the quality we all fight for. But the fundamental thing is to separate the business from the editorial aspects. The editor's office should operate independently of how the medium is financed, independently of the advertising market. The media that survived this period in the way we are proud of are those that really wanted to keep the borders between financing sources and independence of the journalists. That's the foundation to maintain high quality. Thank you very much. I don't know if there are any questions. Referring to regulations. It's like with credits in Swiss francs. There are no regulations, no clear regulations, and hundreds of lawsuits. I asked my lawyer if I can sue Meta and how to do it. We talk about SLAPP, but also there are cases of harassing, of online harassment or on the internet. You can write anything about journalists, anything you want. None of us can hope for assistance from Meta. I have my personal examples as well. I have no technical means to sue Meta in an American court. That would cost a lot. There are some discussions going on in Europe, and they are required at the level of some regulations how to force Meta, this is the key player, to disclose account data. Without that, it's not possible to defend ourselves. We cannot sue anonymous accounts. Yes, there are various ideas how to do it. For instance, like dummy lawsuits. We could instigate proceedings and this way obtain access to data. This is like an interim procedure before we obtain data. That would require the court's control. There are ongoing discussions. I fully agree with you that we need such measures. In the European Media Freedom Act, we often mentioned that the data related, for instance, to algorithm structure could be disclosed. Nowadays, it's not regulated. It opens the way. If we detect some features of the algorithm triggering what you have just mentioned, we could successfully prevent it. Nowadays, we have no access to it, and it's covered by a patent. But such data and analysis could be requested in the future. There is a proposal to certify researchers. If they are able to analyze it and draw conclusions, they could apply for it. There are ideas for the future. For the time being, it's a challenge, I know. I do understand that you refer to some other aspects, but that's the key. Actually, what you get or what the users get is the function of the algorithm which observes, monitors behavior and draws conclusions on some predefined aspects. Thank you very much, and thank you for the questions. I would like to thank my panelists for a very interesting discussion, and I do hope successive panels will be interesting, equally interesting. Thank you.
Dziękujemy bardzo. Teraz krótka przerwa 15 minut.
A quarter of an hour.